That matter's ready, Your Honor.
Right, we're here on a review of a motion to compel the second one. It looks like there was some orders entered ex parte.
Yes, I believe this is actually the fourth one. I think this is the final one. We've been here a number of times. One was ordered ex parte. The other two were hearings.
All right. Do we have Casey Mansker present?
I'm here.
All right. I'm sorry if you go by Bowen now. My apologies.
I do. It's okay.
All right. Okay. So Ms. Winkles, I see, looks like Commissioner Nelson on May 30th signed the second order compelling answers to respondents' interrogatories. And
we keep sending out the notices. I would rather have the discovery because these things, obviously, they don't stay closed even if you get them. We've sent out every notice we can. We've sent out every notice of hearing. Even the ex parte order, we just have received absolutely nothing and no contact at all with my office.
All right. So Ms. Bowen, any reason why you're not responding to these requests?
I am currently not living where I at 82 Chickadee. I did get an email saying I have questions to fill out. When I got an attorney, my dad helped me with an attorney, and then we couldn't keep affording him. And I thought that he filled out those questions and sent that to her. I was on TANF when I got ex parte restraining order, and I have not been currently working. I went to inpatient treatment. I've gone out of inpatient treatment. I've done intense outpatient treatment. I graduated from both of those, and I'm currently in outpatient treatment, and I have no income. I'm currently working, and I just got my two little ones back. So all this stuff, I don't know if I can get a attorney to represent me, but I don't know exactly what I need to file. I've done UAs for Nathan. I have passed. I got the Vivitrol shot. I don't know how to respond to these motions, or honestly, it's over my head. Dawson.
Do you have any of the packets that have been sent to you by Ms. Winkles?
I do. I have the parenting plan, the way he proposed the temporary parenting plan. I got, I think, Ann Heights parenting, or for the guardian litem. I've been going to visits with the kids, but it also costs money to see them, and I don't have any funds, but I've been paying to go see them. They've had appointments the last 2 weeks, so I haven't got to see them, but I'm supposed to see them tomorrow. And I was curious if there's any way that my dad, because he got cleared for DHHS background check, and I just can't afford it right now to pay the money to see them. And it's kind of makes it impossible.
Your Honor, I'm going to object. We're here on a motion to compel. We're not here on temporary orders or any of that.
Yes.
Okay. Well, how do I go about that? I don't know what to file to see if I can, or I don't have to pay, because he knows that I don't have any income right now.
Well, I can't give you legal advice from the bench, first and foremost. Secondly, we're here to review why you haven't submitted any of those answers. So it's been a while since I've reviewed some interrogatories, but I can't imagine that it's not things that you couldn't answer yourself without the assistance of an attorney. If you need an attorney or need help, you need to look at the interrogatories. You need to give Ms. Winkles, why don't you give Ms. Winkles a call? Let her know where she can get a hold of you and how she can get a hold of you. And if you need the information again, but you're compelled, the court's already ordered that you have to answer these.
Okay.
So we're really not, let me talk when I'm talking. We're really not getting anywhere with you because this is just happening over and over again. I completely and totally sympathize with your position when you don't have money or have other children, a lot of things going on. But frankly, this is a pretty significant issue that requires your attention. If you don't get those submitted, the court and Ms. Winkles can ask the court, and the court can just say you're not allowed to present any evidence at trial.
Okay.
And that is not probably a situation you want to be in. So, Ms. Winkles, go ahead.
Can we have a 2-week review then? And she can contact my office. Can we set this over 2 weeks? Because my fears were just going to be here again because we were here before and she was here at the beginning. So I'd ask for a 2-week review. I don't mind that. Like I said, we just want to get this done. If she can contact my office, I'm more than happy to email her another copy of the ROGs. And there are questions that any normal Joe can answer.
Okay.
So Ms. Bowen, you need to call, if not today, first thing tomorrow, Ms. Winkles' office, exchange some information with her, let her know what you don't have that she needs from you. And we'll set this to the 20th of June. I expect there to be some progress by that point in time.
Okay, thank you so much.
All right,
you, Ron.
June 20th, 1 p.m.
Good afternoon, Your Honor. Emily Roberts on behalf of Ms. Hill.
Good afternoon, Ms. Roberts. All right. Okay, and we have Ms. Bliss on behalf of Mr. Hill.
Yes, Your
And
Honor.
we are here to see what's going on with the GAL report, that the final report was due 14 months ago. So what do we know?
So Your Honor is correct that the order with respect to the GAO was entered back in a show 2021, 12/9 of 2021. I have both Ms. Bliss and I have followed up with the guardian ad litem several times. I've sent her letters asking for an update. My understanding was she was previously just waiting for the evaluations from my client. Those have been in her possession for months now. This is really becoming a problem for not only my client, Your Honor, but the child in this case is stuck in the middle of not being able to spend any time with his mom at this point. We just need the GAL report so we can move this forward. And so I'm hoping Your Honor can get to the bottom of why it is we don't have it yet.
Ms. Bliss?
I think that's an accurate representation of where we've been. I do know that getting Ms. Hill's psychological evaluation was one of the largest hurdles that kind of delayed this process, excuse me, prior to Ms. Roberts' involvement. But as she mentioned, we've had that report for several months at this point. I think both parties are looking forward to finalization, but I think that getting that GAL report is necessary prior to reaching any resolution.
All right, and our GAL is, looks like Miss Gravina, and looks like she is present. So Miss Gravina, I'm hopeful for an update.
Yes, Your Honor. This and about several other cases, about 6 cases, all had been pushed out for several evaluations. This one was pushed out for over a year for a psychological evaluation. And they all just came due at the same time. And I'm about 3 weeks behind, but I only need a couple more days for this one and anticipate getting it out Wednesday or Thursday afternoon, Your Honor. This was one of my last ones. I'm wrapping it up. I think I have one more after this, and that's it.
All right, Miss Bliss and Miss Roberts, I apologize for the delay. I mean, frankly, I understand some evaluations are backed up, but this seems pretty extreme delay. If the report is received by Thursday, how quickly do you think we can come back once you receive that?
I mean, if the court's not anticipating us needing to file motions with respect to it, and we're just coming back to discuss and or try and implement pieces of it, I think we could do that quickly. It more probably depends on the court's availability, but I would appreciate getting back on sometime this month.
Would the 20th be enough time?
Let me just look at the calendar really quick. So I would be available on the 20th, and assuming it's received, I'm sure Ms. Bliss and I could work through if there's any issues. We work relatively well together, so I don't anticipate or foresee that, I think we both want to just get this done for our clients. So I'm available on the 20th, could make that work. Even if Ms. Gravina could, even at the offset, if she could have the report or guarantee the report by Monday, that would be fine as well. I just need time to review it with my client and talk with Ms. Bliss.
All right. Does the 20th work for you, Ms. Bliss?
Your Honor, I have no objection to the 20th. I know that your docket's closed on the 27th. My only concern is and I would agree, I think Ms. Roberts and I do work relatively well together, and it's likely that we could reach a resolution, fingers crossed, prior to coming to court on the 20th, and just kind of having that as a backstop. My only concern is if in the event we're unable to reach a resolution, if Your Honor would like written declarations from either client, obviously that kind of impairs our ability to provide that. I mean, we can do it on short notice, but getting that to Your Honor prior to that hearing. Alternatively, if you just want oral argument that day, I'm fine with that as well.
Well, here's what we're going to do. It's been delayed, I think, significantly enough. So, Ms. Gravina, I'm expecting you to have that report to all parties by the close of business Friday of this week, the 9th, close of business. Let's set this to the 20th at 1 p.m. I'm fine with oral arguments on the 20th if there's no resolution, and I'm also fine with last minute declarations to just electronic, essentially email to me. I'll make sure to review those because in looking at this case, I saw how long we've been waiting. So either way is fine. So report by the end of the week, close of business, and we'll set this to the 20th, and whatever. If you mutually decide to just do oral arguments, that's fine. If you mutually decide to email declarations, you can do that, and I'll make sure to review that up through Monday evening. Okay, is Mr. Hummel?
Thank you very much.
All right.
At this point, yes, Your Honor. As of late March, early April, my understanding is he has abandoned the state, abandoned the house, and hasn't talked to his children since. So my understanding is he is completely in the wind.
And he was last present in this case within the last 12 months, correct?
He never made an appearance in the case. He never entered a notice of appearance. He was served on August of 2022 within a year.
Have your proposed orders. I am going to, and I reviewed them briefly. And so I have a findings and conclusion, a final dissolution order, a parenting plan, a child support order, and a child support worksheet. Is that correct?
Yes, Your Honor.
All right. I will
Looks like
sign and
a lot of
enter those
issues
as
were already
proposed.
resolved, and we
Thank you, Your Honor.
Child support was set
Thank
over.
you.
Is that correct?
Is Mr. Hamir present?
Elizabeth Schwanter is present on behalf of.
Okay, thank you.
Hi, good
Mary.
afternoon.
Hi. So Commissioner Nelson heard this 2 weeks ago and basically heard the majority of the issues, but he wanted to set over the financials. Mr. Brown had not filed financials at that point, and so it's set over today for purposes of child support. At this point, there is essentially a no contact order between Mr. Brown and the child. So my client's providing 100% of the child's financial needs. Mr. Brown's financial documentation does show that his adjusted gross after reductions for his mandatory pension in 2021, his annual gross was $57,141. And in 2022, his annual gross was $60,541. So that provides a basic gross of $5,045 per month just from his place of employment. For purposes of my child support calculations, what I did was I took the last 5 wage stubs that he provided, because as you see in those that he filed under seal, he does get additional fees when there's additional children or additional time that he has to spend or additional services that he's required to perform under the union contract for the school district. So in some instances, his gross for the month was a little over $5,800, and other times it's his base, which is the 4,900 and I have to look. I think it was 4,900 some. I'm sorry, $4,941. So that does not include his LCC wages because he coaches on the side. You'll see in his proposed child support calculations, he provides those at line 1E. He identifies as other income, but when you look at his child support calculations, he doesn't equate that as a monthly amount, and that doesn't add to his gross. So he's got his gross at the $4,941 per month. Our position is that the court should utilize our calculations in arriving at the proposed net for him of $3,851.71. It's undisputed that my client's net is $3,463.14. So we're asking the court to order child support at $655.06 per month, commencing April 1, 23. We're also asking that the court maintain the language that I've provided in my proposed child support order at paragraph 25B, which reserves for any retroactive child support for the 5-year statute of limitations under RCW 26.26B.040. Mr. Brown had made or had alluded in his reply documentation when we were before the court previously that he had overpaid child support. And just briefly, these parties had a temporary child support order. That case was dismissed for want of prosecution. Apparently, I'm assuming that the Office of Support Enforcement was not advised of that dismissal, and they continued to either withhold from his wage stub or he voluntarily paid until this case was filed. He's not currently paid child support or had child support collected since April of this year. So we're asking that the court establish an effective date of April 1, 23 for that child support amount. I would also note that in calculating his taxes and arriving at net, I let the computer do the work. I ran him as single with no dependents. When you look at his calculations, he has a federal withholding of $315.89 compared to my $528.83. In addition, you'll see that he did receive a substantial refund last year when he did claim Lauren, we are asking that the court adopt our proposed taxes language that my client claims the child as a dependent moving forward. So that would be for tax year 2023 moving forward. That would be a temporary basis. Obviously, that's something that the court can consider in the future and upon finalization.
All right, thank you. Ms. Schwanter?
Good afternoon. First, I want to tell the court that my client very much continues to want to see his child. He intends to pursue visitation. And I would remind the parties that there has been no criminal charges, no criminal conviction. There's been no founded CPS investigation. And he will, again, it's his goal to establish visitation. Now, that issue certainly has no impact on the child support. I would like to thank counsel for clarifying the issues. I think that she's hit on every single point. At the end of the day, these parties are very close in regard to their proposals for child support. The father proposes $596, the mother $655. And I think that counsel highlighted a couple of the issues as to how we arrived at different numbers. Number one, Mr. Brown is a school teacher, so he does have a base salary. He essentially works overtime by covering other classes. He's not required to work overtime, and he doesn't always work overtime, but he has opted to do so in order to pay bills, and he's indicated that on his financial declaration. Similarly, he has a second job where he's coaching, and again, that is in addition to the 40-hour work week, and again to pay down debts. So for that reason, Mr. Brown has proposed that $5,000 income be excluded from the court's child support calculation, and that accounts for the difference in the standard calculation. Mr. Brown also disagrees with the mother's it's a credit for health insurance, the $43, and that also impacts the small difference that the parties have regarding the child support monthly amount. In regard to the start date, as counsel mentioned, Mr. Brown was garnished for almost a year by DCS pursuant to no valid court order. And so the result is, they over $5,000 he overpaid in child support. He made a payment for April of 2023. So we would ask that the court start the order effective today. Additionally, in regard to allocation of the tax exemption, I see no reason why the parties would not continue to alternate the tax exemption, and I would ask the court to adopt an order doing so. If the court has any questions, I'm happy to answer. But again, at the end of the day here, I remind the court that the parties are very close regarding the monthly transfer payment.
The only thing that I would point out is that in my last communication with my client, she had not received a child support payment. I think I last spoke with her last week. And then the only other clarification that I have is that there's a deduction in Mr. Brown's calculation for $472.19 for maintenance paid. And I'm not aware that he has a spousal maintenance obligation to any former spouses. I have no idea what
that's correct. You're correct. You're correct. That's not accurate. I believe that reflects the amount of child support paid, but that shouldn't be deducted. That's correct.
Yeah, so that's arbitrarily deflating
Correct.
his income then. So again, I would just ask the court to follow our child support calculations.
All right, thank you. So I did review, and I made a note that $60 separate, I think $59 difference in what we're looking at here. I'm going to reserve on any retroactive child support.
Okay. What kind of case are you thinking we're going to hear today?
I'm going to.
So is the court then maintaining the language that I have proposed at paragraph?
Yes.
Okay, 25B, I think it is.
I think given how close we are, I'm going to leave the percentages as they are. So 53.47. So there's clearly some issues with Mr.'s calculations just because of that $472.19 that was deducted that they're agreeing it sounds like shouldn't be deducted. The $5,000, clearly they interlineate that's paid biweekly from November to March for his basketball coaching. And so here's what I'm gonna do. I'm gonna set it at $625 a month. I'm gonna have it start April 1st, 2023. So I'm gonna enter the child support order, but not the worksheet with the language as proposed.
So you're just changing that paragraph 10 then to say 625?
Correct.
Okay. All right, thank you very much, Your Honor. Ms. Counsel, we will provide you with a form copy once they hit Odyssey.
All right, I'm going to pause 1 second. I was just given an emergency warrant to review, so I just need 1 moment. I'm just going to mute myself.
Right. For the record, I'm Chelsea Baldwin. I represent the petition in this matter. This is our motion to show cause re contempt. In this case, the respondent filed his responsive documents very late. And then we did push out a reply really quickly. Did the court get those 2 documents?
I did, yes, and I was able to review them.
Okay, very good. So with that, again, in this case, we're looking at medical expenses, education, and extracurricular costs of $5,686 plus interest on that total amount. My client she informally provided notices to all of these billings sort of throughout the case. Formal notice was given along with, yet again, copies of the materials in early 2023. At that point, or since that point, there's been no payment on those, no efforts to pay on those, no evidence that he is making efforts to pay on those for really at this point years. There's no arrangements that have been made. He did not reach out to try to make arrangements to pay that, and really just no communication. I'm just essentially going to ignore the fact that I owe for these medical bills, and I'm just going to continue to not do anything until a contempt is filed. And therein sort of lies the frustration for my client, is that anytime there's these obligations and they are in black and white, Mr. Schoenborn just doesn't follow through with any of them until we come to this type of a hearing, which isn't a reasonable way for him to sort of conduct business regarding his children. He says that his response is essentially, well, there's only one of these that I paid. My client says, absolutely not. That payment had nothing to do with braces. It had to do with the reimbursement for monies he improperly took from her HSA. She provides all the documentation that establishes that. So again, he hasn't paid on that. All he's done is reimburse her for monies that he improperly took. So in this case, it's very clear that there's contempt as to the past due medical bills that my client then has been in a position where she's had to pay to be able to get the children to continue in care, continue in their activities, continue in the things that they need. The second piece of the contempt is simply just Mr. Schoenborn failed a drug test. It's very clear, sort of loser pays language. He failed the test. He owes for the cost of the test. He's made no efforts to reimburse my client for that. Again, sort of just ignoring it and moving on with his day. So again, that's another clear contempt. He's made no efforts to reimburse her despite request. So at this point, we're asking the court for a judgment as pled for, which is the $5,686 plus interest on that amount. The $350 for the failed tests. We're asking for fees in the amount of $2,500. Again, that sort of encapsulates the efforts to get him to comply, as well as today's hearing and any subsequent hearings that are necessary. Costs in this case would be $130, $100 for the service, $30 for the ex parte fee. And we're asking for a sanction of $1,000. Again, this is sort of very much repeat behavior from the last contempt as far as coming before the court. And we're once again in a position where sort of nothing is done until we're here on a contempt. Mr. Schoenborn needs to understand that's not a reasonable way to do business. When he gets a letter, he needs to respond to it, make efforts to pay, should comply from the outset. We just don't have any of that. And that's why that heavier sanction is appropriate. So we're asking the court for that ruling.
All right, thank you. Mr. Schoenborn?
Can you hear me, Your Honor?
I can, thank you.
Okay. So, yeah, I did do a reply kind of late. I've been really busy with the interviews and stuff. For right now, I want to skip the proof of all my job searches and address that first bill that they're stating that was for an HSA. That bill that we're talking about is actually the first page on her financial document packet that she turned in, Wagner Orthodontics. You could see how much it was where it says patient responsibility $1,250. This was the only bill that was submitted to me until February. You could see from my exhibits B and C that I not only paid 54%, I just paid the full $1,250. You could see by the receipt, it says 4 braces. Then you could see the email talking to my lawyer saying, let them know that the braces money is being paid, or a communication. She's only provided proof that I used our family HSA money for a medical bill. And we were completely under her medical insurance at the time of the breakup, and I was still under her medical insurance. And so I used the HSA to pay medical bills. I asked my lawyer if I should repay that back. He said, no, that's a community fund that you used for your medical bills, and that'll be addressed during the finalization of the divorce. So no, I did not pay the HSA back. I clearly, with proof, paid the orthodontic bill of the full $1,250. I'm not trying to, you could see in my reply, I'm not trying to say anyone's a liar or anything. There's been a ton of miscommunication in this trial for the whole 3 years. But she says that she informally told me about all the other bills throughout the 3 years. We aren't able legally to speak to each other. So the only way to communicate is through lawyers. And there is no emails, no bills sent to my lawyers. I put a exhibit D just showing that I double checked with my lawyers, seeing, hey, all these bills showed up in February. How come I didn't know about them? And they said that they didn't receive any bills. So yeah, I'm at the point where now in February I get $5,600 worth of bills. Lumped in with that, you could see her exhibit A, the email they sent me. In the middle of the email, it says, "Oh yeah, you owe $350 for the failed UA," and then at the bottom in bold it says the full amount. I took that full amount and been keeping track of that on what I owe. But again, that was 3 years worth of bills that just showed up in February. I'm not denying that I don't owe that, and I'm not even arguing that she could add the insurance of not paid for the last 3 years, even though there clearly, it wasn't told to me that these bills existed. I wanted to bring up that they keep saying I don't pay anything until I'm forced to pay, and they use the example of the last contempt hearing. It wasn't until the contempt hearing that I paid $11,000. So I put in Exhibit E showing the date that was paid, and it was well before I knew about the contempt, before I was even served about the contempt. That was just following the directions of my DSHS supervisor on getting that paid. And that was all contingent on the PGE job that I was in the middle of interviewing for. If I didn't get it, then I had to figure out a way to pay the $11,000. If I did get it, then she could start garnishing my wages right away. I failed to get that job, and so with my parents' help, I came out to that $11,000. And then the last one is, with not having any bills sent to me for those 3 years, when I was getting unemployment money, anything I had left over from the child support payments and my medical bills and treatment bills, I was sending to her. You could see in Exhibit F and G, there's my spreadsheet that I kept just to keep track. And then G is bank statement showing each payment, each date the payments were made. You can't open them up because it's just a copy, but I actually put notes in there, help out with the kids, help out with insurance, just to help out. I put a note on every single one. And that's because I wasn't getting any bills, but the kids were doing sports. So I knew she was paying for something, but that was not communicated to me at all. So I put that in there just so you could see that, that was good faith, and I was trying to help out as much as I could with real poor communication on the other end. I just got in the mail a $9,500 bill, soccer. I guess my daughter got into a real nice soccer team, which I'm super proud of her about, but it was $1,800. And so now it says you owe $950, pay in a week and a half, and that's it. I had no say in that. That's not medical bills. I know I owe it and I want to pay it, but we proved on the last contempt hearing that, I can't afford to pay these bills right now. I'm unemployed. It was stressed to me very much so that I need to be working on getting a job, and that I didn't do a good enough job explaining the jobs that I was looking for. So this time, in Exhibit A, I wanted to make sure that it was real clearly printed out. Now, her lawyer did say in their response that anyone can make that up. That's not proof. So I did print out every email saying thank you for the replies, or for the applications, all the emails showing when my interviews were or coming up. There's a note in there for Nippon Dynawave saying they were going to contact me yesterday. They did, and they asked for an interview for today. I had to reschedule that to Monday. I have that email that I could send to whoever to prove that. And then the second one, WANA, I'm supposed to call them right after I'm done with court to try to come up with a day this week to go interview for those positions. The last thing was they said that I'm applying for jobs that are out of my skill set. I don't know how they know what my skill set is or not, but every one of these jobs is bottom of the line entry into the mill that I could work myself up in. They're jobs I've done in the past that I'm well overqualified for. The only two that she could even be looking at are the superintendent roles in WANA, and that was because the mill manager asked me to apply for those. He wanted to talk to me about them. I told him I was more interested in the lower OMC role just to get back into work, but he told me to apply just because he wanted to discuss that with me. These interviews are coming up, hopefully this week. For sure, the Nippon ones are on Monday. If I'm not providing enough proof that I'm doing everything I can to get a job so I could pay these bills, I'd like to know what do I need to submit? What is worthy enough to submit to show that I'm doing everything I can? Because my parents are helping me out. They're paying this child support. They don't want to be doing that forever. So they're helping me as much as they can, looking for work and stuff. And I think from April 11th till now, I've done a pretty good job of how many interviews I went to and where I'm set up on this WANA Nippon thing coming up. I feel really good about those. They're both pulp mill jobs, and I've been in the pulp mill the last 10 years of my life. So there's a very, very good chance I'm getting at least one of those. I'm stuck because, again, I don't know what other proof I need to bring from the April 11th contempt hearing to now. I was told everything was fine and to keep paying the child support. And the judge asked, I think it was you actually, is there any other thing anyone wants to bring up? Those bills weren't brought up then. There wasn't a payment plan brought up. We're willing to do whatever it takes. And the last thing I put in my reply was, my parents are willing to take out a loan to pay this if it can't wait until I get a job, or if we can't come to an agreement on a payment plan. But they're willing to help out too. And they just brought that up to me last week. It wasn't something I was going to ask for, but they could see I'm doing everything I can, and I will get a job. I'm not going to give up. I'm not going to keep trying or quit trying. It will happen. And it sucks for everyone that it hasn't happened yet, but that doesn't mean I'm not doing everything in my power to pay these. Thank you.
All right. Thank you, sir. Ms. Baldwin, anything else?
Yes, thank you. So let's address, there's two prior temporary orders, one in May of 2020 and one in June of 2020, both which put restrictions on use of community funds. It's important to keep that in mind when we establish the idea that essentially Mr. was presented a bill for the child's braces. He admits he got that bill. He then took money from my client to pay her. And the ridiculousness that is, he literally took money out of her account and then gave it back to her and said, there's the payment. It's like, no, that was her money to start with. That was not a payment. All he did was give her the money he took out of the account to start with. Not proper based on the prior orders that said you can't use funds that way. And so again, hasn't paid that, admitted that he received that. And essentially it's like, well, I know I did something wrong. My attorney just said, well, we'll figure it out later. Well, again, now it's 3 years later and he's still never paid that bill. Similarly with the other bills, there was not a protection order between these parties until 2023. That's when that was entered. There's the correspondence from February, there's correspondence from March that are indicating bills that are coming in and being provided to him, even if he didn't get them before that day. And again, my client disputes that. And it doesn't really match with the evidence of him saying he received some of them and kind of maybe made payments. It doesn't really match with that evidence. But even if you only got the notice in February, he still did nothing. He still paid nothing. He acknowledges he owes, but essentially it's like, well, I'll get to it when I get to it. And again, these are bills that are due and owing that my client has to shell out the money to pay for. This idea that, well, I gave her extra money here and there, not attached to anything. Child support are very clear. If you give the other party extra funds, they aren't applied to anything. And those were done in 2020 and 2021, 2 years ago. So again, not anything to do with the current bills we're associated with. So at this point, the amounts are due and owing. They do need to be paid. He appears to have means or access to means to have them be paid. They should be paid so that my client, again, isn't the one who is sort of having to choose to pay Peter or pay Paul with her finances to make sure that the children's medical care, education, and other needs are met. So we're asking for the judgment. And since he has the means to pay, I'd ask that we set a review just to make sure that that payment happens.
How was Mrs. submitting these bills to Mr.? I guess, was it like, did they have a process? Like they were emailed, they went through you? I know that this case, there was a accompanying criminal matter. Was there a restraining order in that prohibited contact?
That I don't know. There was a collateral criminal matter. I don't know. There was some orders in that regarding restraint, but I don't know if they prevented all communication or just sort of like a do not disturb type of an order. I'm also not.
Yes, Your Honor.
I've only been on the case for comparatively a brief amount of time. Prior, there was Ms. Winkles and I think another attorney. So I'm not sure what the process was used. We used the letters that you have in your file are the ones that were initiated by my office. So I can't tell you the process that was used before me.
Yeah, from the criminal matter, there was a no contact order. So everything had to go through the lawyers for communication.
All right, and looking back all the way back to 2020, it appears that there was a restraining order entered and there was reference to a criminal restraining order. So I guess there's a little bit of concern about how those were communicated. And the 1250 is the 1250 part of the 5686, I'm assuming.
Yes,
okay.
That is.
Okay. All right. I've seen this case quite a bit. I understand both parties' concerns. I think both parties are in a very difficult situation and doing what they can to remedy that in the best way that they can. I'm not. There are a lot of things though that are pretty cut and dry and that just haven't been done. There's language for the failed drug test, so that was, I believe it was last month or late April. I don't have that part pulled up in front of me now. December. Sorry. So it was that long ago. So that's pretty clear language. Nothing's been done there. I am going to make a finding contempt, but here's what I'm going to do. I'm going to adopt the amount because I think it's relatively clear that amount is what's owed at this point. So the 5686.39. I'm striking the interest. I'm going to say 12% interest will begin accruing if not paid within 60 days of this order. I'm striking the interest on the $350, but I am imposing that $350. Will grant $1,000 in attorney's fees. I'm striking any civil sanction, and I will impose the $130 in costs. So I've made those changes to both section, 1 and 8. So that language matches up and I'll enter this order. So essentially, Mr. Schornborn, I am banking on you getting one of these upcoming jobs. And my hope would be that we don't see you again because things will start getting sorted out and garnishment can start. And hopefully both of you will start getting to a more reasonable place in the near future. I know, Ms. Baldwin, you requested a review. Do you want to set a review approximately 2 months out just to see where we are? That can be struck if he does get employed and we can get a garnishment set up.
Yeah, that sounds appropriate. How about
do August 1?
Yes, August 1.
Okay. So Mr. Schornborn, we're going to set a review for August 1st. Here is my sincere hope that you will be employed by then and we will be able to strike that review because a system will be set up for better communication about relaying any bills that are owed, and then child support will be taken care of by way of your paycheck. So I wish you the best of luck on those interviews upcoming. And
thank you.
We'll see you on the August 1st at 1 p.m., but hopefully we won't see you on August 1st at 1 p.m.
And in that 6 months, that's just no interest for 6 months, or 6 months is the deadline to get that. Oh,
No,
60
it's just
days for
60 days, no interest.
Sorry.
And then it doesn't do anything to, I mean, all that would happen after 60
Okay.
days is if it's not paying is it would start accruing interest at that point.
I'm hoping we don't even get to that point. So, all right. Thank you so much,
Okay.
Your Honor.
All right. Good luck, everyone. All right. We're here for temporary orders. Just so everybody is aware, I reviewed everything. I don't see anything was filed after May 23rd. So hopefully there's nothing that I missed.
We didn't file anything since then.
Okay.
No, Your Honor.
All right. And I see we have Miss Powers here. So any objection to me starting with her?
No objection.
All right,
None.
Miss Powers.
Thank you, Your Honor. Both of these children are receiving TANF benefits, so we did go ahead and file proposed child support worksheets. We filed initial worksheets on May 1st, and then we received additional information from the father, and so we updated our worksheets and filed amended worksheets on May 18th. In computing child support, we used the father's actual 2022 income per employment security data. We also included voluntary retirement deductions per his December 30th, 2022 pay stub. The father provided information about the cost to insure the child in 2021. I did not include those in our worksheets as they were outdated, and I didn't have sufficient information to feel it was appropriate to include those. For the mother, we imputed her at minimum wage 32 hours per week as she's a TANF recipient. All of that results in a transfer payment of $15.46 a month. TANF began in February, but the petition was filed in April, so we're asking the court to set a start date of April 1st.
Either party have any questions for Ms. Powers?
I do not.
I don't have questions. I have an argument I'd like to make based on some specifics, but I can wait when the court wants that.
Go ahead, Ms. Roberts.
So with respect to the differences between our worksheets and the state's, our worksheets were off, but it's a couple $100. I think the overall amount was off by $260 a month due to the excessive overtime that shouldn't be recurring due to the letters that we included in Exhibit 5 of our declaration. Also, $300 or so per month were different from the state's with respect to income tax deduction. The reason our worksheets are calculated that way is because the 2022 data was his deductions were calculated and taken out based on his status as being married. He's no longer going to file jointly. So I calculated his deductions based on a single filer. So I'd ask that the court adopt our worksheets or ask that the state modify because it's going to net him $300 more per month. It just is not a real number. I understand why the state did it, but it's not going to happen going forward. And the numbers that court has in front of it are going to be inaccurate. And I'd ask that if he can get, and we were waiting on HR, but if we can get the updated numbers, if we could have the health insurance premium included in the final order or a temporary order that's signed.
Okay. Ms. Bliss or Ms. Powers, any information there or want to weigh in on that?
We just have a short reply. In calculating the father's income, we used the employment security data, which showed he worked 1,567 hours in 2022. That averages out 30 hours per week. So I don't believe there was overtime included in his income. And then in terms of taxes, we put him as single one for our federal taxes. So I'm not sure why the taxes look different between the two worksheets because we did put him in as a single filer.
I don't know why our calculations are different. I can talk to Ms. Powers off the record with respect to that. We submitted many of his pay stubs for 2022, and I believe he was working more than 30 hours per week, but I didn't add everything up because I don't have anything else to add, Your Honor.
Okay. Well, let's table that for a second. And Ms. Bliss, your party is the petitioner, and I don't know, I guess, are the parties, Ms. Powers, you're more than welcome to stay, but if this is the only matter that you're here for, I don't know if Ms. Bliss, you have any objection to kind of holding off on the child support if Mr. Roberts and Ms. Powers can have a conversation, including you, for where the discrepancies are and potentially do that portion ex parte if it's agreed.
I don't really have any objection. I noticed in our filings, and I think I reflected that in my client's last declaration, is my worksheets and Ms. Powers' updated worksheets are a difference about $50. So depending on what those discussions, I think we can table this issue, and obviously, depending on what happens today, I imagine Your Honor is likely going to make some revisions to the orders that I've prepared. So maybe addressing that issue and then coming back to that on a potential presentation date. I don't have any issue with that if they, given the fact that at least as of right now, our numbers are so close.
Okay. So I guess, Ms. Powers, if you want to stay, you're more than welcome, but you're free to leave if this is the only matter you're here for, which I don't know, it may not be. So
Thank you.
thank you. Okay, so Ms. Bliss, go ahead.
Thank you, Your Honor. And sorry. For the record, Carly Blitz on behalf of petitioner and moving party, namely Ashley Wetmore. This matters before the court today on my client's motion for temporary orders. Your Honor just addressed the child support issue. I, again, for the record, would just note that my worksheets, which had Mr's 2022 income, or 2021 income, excuse me, used for purposes of that calculation. Again, the state's most recent worksheets, there's a difference about $50. I would defer to the court as to adopting either of those worksheets. I do think it's appropriate, given the fact that my client is on TANF, that she be imputed at the 32 hours per week at minimum wage, as Ms. Powers has done. I do believe by statute that that's required. I will note that in Mr's proposal initially, he had requested imputing her at a higher wage as contained in the declarations. That's inappropriate, even by statute, given the fact that she's a current TANF recipient. So I think that covers the child support issue. More importantly, regarding the parenting plan. So as Your Honor's aware, my client is the mother of 2-year-old Brady and 1-year-old Carson. These parties were married for a very short period of time, but birthed 2 wonderful boys in the process. My client provides in her declaration that she had been the primary parent for these children since their birth, that she was a stay-at-home mother during the course of the marriage to care for these 2 boys very close in age. So whether she was pregnant with one child, raising one child and pregnant with the other, or raising both children during the course of the marriage, she was unemployed. She provides for the court that Mr. was the primary provider during that time when he would be at work. Obviously, she'd be caring for the children. When he would return from work, again, she provides for the court that she solely cared for the children, that she was required upon Mr's return home to not only care for those 2 young children, but to also care for him. She provides this for the court to kind of provide the court a little bit of a scenery as to the dynamics of the household. She provides for the court that Mr. was in control of the finances and kept her in the dark completely. So that was a lot of discussion in her declarations. Since the parties have separated, and my client provides for the court that in October of 2022, she moved out of the family home, which is in the local area, and relocated to Kennewick, where her family is from. She provides for the court that upon moving to Kennewick, visitation with dad was essentially on his days off from work. And she provides, and there's been several calendars provided to the court to reflect that. She believes that her parenting plan that she provided to the court largely encompasses that, provides dad with substantial visitation on his days off from work, and yet keeping the children with their status quo and with their primary parent. Father's proposed parenting plan suggests that these children would be away from their primary parent for 2 weeks at a time, which is far more than they have ever done. Again, this is a 1-year-old and a 2-year-old being away from their primary parent and provider for up to 2 weeks at a time is excessive and inappropriate. Not to say that as these kids grow up and in age that may become appropriate, but at least at this juncture, it's not. So my client provides a parenting plan which largely encompasses status quo and provides father with 4 days per month on his days off from work. Again, looking at the schedule, this is largely what the parties have been doing since they've separated. Further, if the court were to look into father's proposed parenting plan, in that 2 weeks time in which he would have the children, one of those weeks he would be on the graveyard shift. So these children wouldn't be in his primary care overnight, nor would they be in his care when he's sleeping for said graveyard shifts. Instead of keeping them with a parent, they would be in the care of a child care provider, an extended family member, or the like. Again, this is contrary to the children's best interest, at least at this juncture. My client provides for the court that during the course of the marriage, there were issues with alcohol consumption, mainly as it relates to father and his consumption of alcohol. She provides for the court that during her pregnancies and shortly after the children were born, she had hoped that he would slow his alcohol consumption. However, that was not the case. She provides for the court that she believes that it's in the children's best interest, especially given their tender age, that a restriction to alcohol be included in any parenting plan that's included. That's included in my parenting plan at section 4, includes 24 hours prior to visitation or during visitation. Again, given the very young age of these children, it's simply inappropriate for either party. But in this instance, father is the one where there's allegations of alcohol abuse. My client provides for the court that since the parties have separated, Mr. has provided minimal support for these children. She's asking the court to not only name her primary custodian, enter the child support order as we've discussed previously, but also enter an award of spousal maintenance. She acknowledges that this is a short-term marriage of just over 2 years. However, during that time, she provides for the court that Mr. again was a primary provider of the household, paid the bills, gave her a budget to go grocery shopping, or simply told her no, she couldn't go grocery shopping because it wasn't in the finances, at least at that point. Since separation, again, he has provided minimal, but still attempted to support the family. We're asking for transitory maintenance in the amount of $1,500 per month. Again, looking at the mere incomes of the parties, she's unemployed, receiving TANF, at least based on the worksheets. At least at my initial worksheets, he was making nearly $8,000 per month. She provides a budget to the court for reference. Her monthly budget, at least as of right now, is nearly $4,000. She simply just does not have the funds to support herself or these children who are in her primary care. So we do believe that at least a transitory maintenance of $1,500 per month is appropriate. Again, I understand the brevity of the marriage, so it would be appropriate to maybe address this as the process goes forward, but we do believe that that's appropriate, at least at this juncture. Looking to the assets, the largest and main asset these parties own is this family home that Mr. is currently residing. My client provides in her declaration that she has received foreclosure notices, that Mr. has not been paying the mortgage timely. We're asking any order that be entered today requires him to maintain the mortgage, maintain the assets. We're also asking, given that foreclosure notice, that the court order that this house be sold immediately. Pending that sale, he shall maintain all obligations in a timely manner to preserve the asset. But given the inability of Mr. or refusal of Mr. to pay the mortgage payment and potentially setting this house into foreclosure, which is the largest asset that these parties have, it's important that we maintain that asset. And I think selling is probably the easiest and most effective way to do that, at least at this point. If the house is sold, I'm asking that those proceeds be placed into a trust account. I know in my client's declaration, she had requested they be placed in my trust account. Obviously, at that point, Mr. was unrepresented. I have no preference whose attorney's account they're put into, so long as that they're preserved pending further litigation. Those are the basis of my requests. Obviously, there was a lot of other discussion as to bills and the like. I think most of those can be disclosed during discovery. Initially, when my motion was filed, we simply had no information from Mr. I'm confident now that he has counsel appointed, we can work through that. However, we are asking that Mr. be obligated to pay any and all debts that are currently in his name. Again, we're unaware of what exists as he was the sole primary financial provider. If there are any credit cards, personal loans, and the like, we are asking that he be obligated to pay all of those timely, pending further litigation.
All right, thank you. Mr. Roberts.
Thank you, Your Honor. So much of what Ms. Bliss relayed to the court is unsupported accusations and testimony from her client, when much of what she's saying is something that would have been documentable. There's a lot of dispute about how the children were taken care of when the parties were together. My client firmly disputes the way that mothers characterize their relationship as well as the parenting. My client indicates he was a significant, if not equal, partner in the child's lives when the parties were together. And he has had the children for significant periods of time without mother present, up to 13 days in March, when she consented to him having the kids for 2 weeks. She didn't relay any significant issues with that visit, but then says that his parenting plan is unreasonable and something the kids should not have to endure when they have endured it and things seem to be going just fine. Mother relocated to a distant location, presumably to be with family to support her, both with childcare and with emotional support to get back on her feet. According to her own story, the parties separated in October, and she is still unemployed. I understand she's on TANF, and I'm not going to argue with the plain language of the statute with respect to how the child support work should be calculated. However, her being on TANF begs the question of what has happened in the past 9 months, or 8 months, excuse me. She's still unemployed. She lost her job due to not taking a vaccine during the pandemic. And she's been voluntarily underemployed since then, which has left the parties in financial straits that have resulted in my client having to sell his vehicle to purchase a much cheaper vehicle to make ends meet. Obviously, the parties had financial conflict and arguments resulting from it. I think that's pretty clear. But mother's not, her whole argument about spousal support is that she needs some money to get back on her feet. How much longer are we going to go? It's been a 2-year marriage, according to her. It's been 8 months since separation. At trial, what is she expecting to get? It's not going to be more than 8 months of support anyway. We've already been there, and she's asking for support for how long? She hasn't even presented to the court one job application or even declared to the court under oath that she has applied for any jobs or that she has a plan other than collect child support and spousal support while my client works and has to travel 400 miles round trip to pick up the children because she refuses to meet him midway. My client's vehicle is not one where he can travel that full distance either because he has a lower quality vehicle now. He's been borrowing his mother's vehicle for those trips. So her claim that she'd have to do the same thing, the parties are in the same situation. My client's working full time. She's unemployed. She doesn't want to even meet halfway. It really begs the question, what is going on and what is her plan for her life other than just wait until the money dries up? before I forget the parenting plan, obviously my client wants the court to adopt his proposed parenting plan. Mother should be getting back to work any day now. She should be. I don't think she's going to at this point, given what she's proposed to the court. And extended family is going to be providing care to the child. My client's mother lives locally, just like mother's family lives very close to her. And grandparent support is going to be involved with childcare during my client's time. When he works graveyards, he takes a nap in the morning and take a nap when the kids go down. It's not an ideal situation, but given the fact that she moved 400 miles away, and my client was very involved in the children's lives, he should have some robust time with the children, not limited to 4 days a month when he is driving 9 hours a day round trip to pick them up, which is what mother seems to be proposing. Also, we're requesting that Father's Day just be specified now because it's coming up in 2 weeks and we want to make sure that's covered before I forget. Mother's current lack of employment coupling with their mismanagement of the mortgage payments can only cast doubt on her veracity and or capacity regarding the financial history of these parties. She makes a lot of accusations, no documentation. She talks about foreclosure notices, but all she provides is some notice saying, if you haven't paid, it could put the house in jeopardy. There's no proof that any payment hasn't been made. And if it existed, she would have provided it to this court. It's been 2 months since her motion and no evidence showing that there's been that there is any deficiency is in front of the court. So the court can conclude that there is no problem there. Even with her reply declaration, when she was called out for it, she's still not explained where the $8,000 that my client gave her for the mortgage from 2021 went. She claims she was embarrassed to talk to him about mismanaging the funds and not paying the mortgage, but she still doesn't tell the court where the $8,000 is that he gave her, and then she had to take a loan out from a friend to repay to save the house. Thank goodness for the COVID moratorium. Otherwise, they may have lost the house due to mother's mismanagement of the mortgage and her recklessness. Her accusations that my client's mismanaging funds simply doesn't square with the fact that she left a lucrative career in a manner that I would argue is at least is voluntary in some capacity. She wrote in her declaration from April 10th that, quote, from her declaration, since our separation, respondent has not assisted with the boys financially or physically, period, no caveats, no nuances. This is simply false. We provided documentation that my client provided her about $2,800 from her date of separation until she filed that motion. She misled the court with that statement with respect to finances. He also provided her an extra $300 on May 24th and $100 last week. This may not be satisfactory to her, but it is simply misleading and dishonest to say his contributions were zero, which is precisely what her declaration under oath stated. She also acknowledged that he had solo parenting time for significant periods of time without her present for multiple bouts. But then she also says he's not assisted with the boys at all physically during their separation, which again is false. Her word cannot be taken at face value. And since she has no documentation or supporting declarations, her statement should be taken with a significant grain of salt. With respect to spousal support, it doesn't make sense she remains unemployed despite separating in late 2022. She claims she was, quote, forced, that was her language in her reply declaration, to seek TANF, but it's unclear if she's even applying for jobs since then. She's living with family. It's unclear if she's even paying for rent. And my client has given her maybe not a satisfactory amount to her, but he's given her thousands of dollars since she separated. It's a 2-year marriage. Separation was 8 months ago, according to her. My clients provided financial assistance and supported her for a full month at his home when she didn't pay any expenses. She also remains on my client's medical insurance, which is several $100 a month expense. That's included in our documents filed under seal, although we can get the 2023 documentation if that's going to be significant. If anything, those numbers are going to be higher. He's also paying off a 401k loan that the court can see in his pay stubs filed under seal. The 401k loan is approximately $300 a month that he does not have access to, which is a community debt accrued during the marriage. And if the court's going to order any support, it should be reduced due to the community debt he's paying off and doesn't have liquid assets to access to, and the medical that he's paying for her. Also, if there's going to be any spousal support, whatsoever, I ask that there be a hard end date. I know Ms. Bliss talked about revisiting later. Revisiting later is going to cost money. My client is operating on limited funds. He couldn't afford to pay the retainer in full to my office, and it's been a really struggle for him. If the court's going to award any support, it should be just for a few months and end, and then she can make a motion for need at that point. If she's still unemployed in September, that indicates a problem on her end, not one that my client's not providing adequate support. It will have been a year after separation. She's still asking for support on a 2-year marriage, which is simply unreasonable. If the family home was in danger, as I already said, she would provide some documentation. It's not. My client has no problem maintaining the asset. It's the only asset he has. There is no issue. There has not been an issue other than some late payments, but he's made the payments. If the court were to force him to move, to force the home to sell, he'd be spending more money during the pendency of this separation and this divorce proceeding to rent an adequate space for the children to stay. I've said all I want to say on child support, except for if there is a support amount, we need to deduct that in the worksheets. With respect to fees, I asked the court to deny that. My client said they can't afford it. He's going to be paying child support. Mother should be responsible for her own fees. It's a short-term marriage, and my client's not flush with money. And I would submit.
Thank you, Mr. Roberts. Ms. Bliss, anything else?
Just briefly, Your Honor, the suggestion that my client, who was rearing 2 children throughout the course of this marriage and was unemployed, given the parties have separated 8 months ago and is now continuing to seek support nearly a year later, I asked the court to consider the fact that my client hasn't received any support from her spouse. Yes, she acknowledges or has been provided to the court that some payments have been received. However, as Mr. Roberts had indicated, it's non-satisfactory. Even with the court's, even with the consideration of all of the child support before the court, the obligation that Mr. is looking at is $1,500 per month in child support, excuse me. So to say that he gave her $200 here, $300 there, it's simply not insufficient. My client has provided the court that she does have a significant amount of debts that she's paying now that she's living on her own. She has a budget of nearly $4,000 per month, 0 income, receiving TANF, and infrequent support from Mr. in this avenue. So she is asking for spousal support simply because she has not received it. Mr. Brings up a significant amount of allegations about she chose to move 400 miles away, so on and so forth. Yet there's been 0 objection to her doing so since she did in October. The parties have operated under a temporary arrangement prior to coming before the court. It has largely worked. Now Mr. is requesting additional time. Again, I would ask the court, and as contained in my client's declaration, it's clear that the motives of Mr. are financially motivated at this point. He doesn't want to support his wife. He doesn't want to support his children, which he did throughout the entirety of the marriage, and is expecting her to essentially get off of her butt when she's solely providing physical support for these 2 kids and go out and get a job. I'm sorry, but you have a 1 and a 2-year-old that she is providing, but for a couple days a month, 100% of the care of. That's simply not feasible at this time. The parties knew this was the agreement of the parties that she wouldn't work during the marriage. And that's simply why we're before the court today asking for maintenance. Again, this is a short-term marriage. I'm not asking for an extended period of time of maintenance, but she does need some maintenance to get back on her feet.
May I briefly respond?
Very briefly.
If there was childcare expenses or any expenses whatsoever, she would have submitted some kind of documentation. My client disputes that. There wasn't an agreement that she wouldn't work during the marriage. She lost her job and they had to cut costs, and she didn't want to sell her car. And there were significant issues about the finances. My client cares about his kids more than anything. As he put in his declaration, he'd relocate if it meant more time with them. He's trying to deal with his long distance relationship while in the early stages of divorce. Thank you.
Thank you. And then this question is to Ms. Bliss. Of note, in the reply declaration from Mr. Buckley, he indicated that there were several periods of time where he had the children without your client. Does she refute that? I mean, one was up to 13 days in length.
Since separation, Your Honor, is that the
Yes,
statement?
like in this year.
March 4th to 16th, I believe.
Right. So it's my understanding, at least in her responsive declaration, that she acknowledges that there have been periods of time in which they have spent together. She indicates on page 2 of her declaration the various days in which he was exercising additional visitation. And it simply said that that's contrary to the best interest of the children moving forward. A one-off, 13-day visitation is one thing, but a consistent 2-week schedule apart from the primary parent, she argues, is contrary to the children's best interest.
Okay. I must have missed that part. Thank you. I have a lot of proposed orders here. I was considering trying to modify them, and I don't know that I can, but here's where I'm at. This is obviously a very short-term marriage. Obviously, 2 children born of this marriage within that short period of time and are still very young, ages 1 and 2. I'm gonna start with the parenting plan. First, I know that there is a 191 accusation of substance abuse. I'm not going to make that finding at this point, so I'll reserve that, and I'm not going to give any limitations. So any decision making is going to be joint. The custodian will be Ms. Wetmore, and looking at an electronic copy of Mr.'s and a paper copy of Mrs. proposed parenting plan, I have a question. So there was a schedule that's attached to the declaration, and in mine, day shift and night shift, that it all is just gray. So it doesn't, there's no way for me to look at this, unfortunately, and tell which is night and which is day. I'm sorry. Assume that the white part is the days off. So like, for instance, if I'm looking at June, I show the 2nd through the 5th is shaded, the 9th through the 11th is shaded, 13th through 15th shaded, 19th through 22nd shaded, and the 30th is shaded. So that's, so I don't know which one of those are nights, which ones are day.
And I apologize, Your Honor. I thought we sent courtesy copies in color, so I'm really sorry about that. My client can chime in if I got something wrong, but I would just direct the court to page 3 of his declaration, because I put some dates specifically in there to help the court walk through it if it was confusing. His proposal was he'd like, and I'll just read from his declaration. He'd like to pick them up on the first day of a 7-day break, keep them through the night shifts, then return them the day before my day shift starts again. And he's referring to, for example, May 26th through June 8th. So that period of time, May 26th through June 8th, June 23rd through July 6th, those are the night shift days, not the day shift days. I hope that's clear. I'm sorry.
Okay. So it would be essentially like a 2-week on, 2-week off proposal.
Something along those lines, if the court would accommodate that, yes.
I was thinking more, and I don't know because, and I did see that. I was thinking, I don't think 4 days is sufficient. So I want father to have more visitation, but I also don't think several trips across the state a month are appropriate either. And so I was hoping that there could be an 8-day range every month. And I don't know if that, it appears as though that wouldn't necessarily fall in the same weeks every month. But then again, I look and I see like the 23rd through the 29th of June for 2023 appears to, there doesn't appear to be a shift during that period of time. The 21st through the 27th of July, there doesn't appear to be 18th through 24th. So,
I think if it may be helpful, at least getting that parameter of an 8-day range. I don't imagine that Mr. Roberts and I couldn't work through the schedule and try and figure that out with a colored copy that we can kind of weed through together.
If I knew in the, sorry, Your Honor.
No, if that is something that you feel that you could work out, 4 days it's not going to cut it. I think it's appropriate. Dad's been with the children for longer lengths of time. Doesn't sound like any of the children are still breastfeeding. I have no reason to believe, based on what I've reviewed in this case, that dad hasn't been an active member of the kids' life. 4 days isn't sufficient. 14 days may be a little extensive given the age of the kids. So I'm looking in between an 8 and 10-day range, and ideally in one trip, if the parties agree that to split that into 2 trips a month. I don't have really, I'm not going to be upset at that. I just know that transportation could potentially be an issue given the distance. I didn't see a huge difference in the proposed parenting plans for holidays, other than I think holidays are relatively agreed. I mean, I think odd years one, even years the other. So I'll Mother's Day with mom, Father's Day with father. So I'll adopt the holidays as proposed to me, unless someone can point out it appears that they're relatively similar. I'm not going to require any substance abuse treatment, but I do want a provision that shouldn't be drinking in front of the kids, actively drinking in front of the kids during your time with them. Temporary family law order. I reviewed that. I'm gonna enter that with a few changes. Is there, Ms. Bliss, does your client have, I guess I've never experienced a mortgage company saying only one person can pay the mortgage before. So is there anything that she needs to do to ensure that that Mr. Buckley can pay that mortgage payment? Because if there is, she needs to make sure that happens. I'm not going to order the sale of the home at this point. The mortgage is at a position. I don't know that Mr. Buckley could find an apartment for that rate. So he will need to, so Mr. Buckley should keep the home in good functional working order, maintain the property as well as it can be maintained, and maintain the mortgage payments. If Miss Wetmore needs to do something to enable him access to be able to pay the mortgage, then I'm ordering that she do that. So Mr. Buckley will pay the mortgage and he can remain living in the home. I am going to order a one-time contribution to attorney's fees in the amount of $2,500. I'm not going to make that due until August 1st, 2023. So I've made that change in section 1 and section 12 of your proposed order. Frankly, since child support was tabled a little bit and the requests that we have, so there's essentially the state and Ms. Wetmore are asking for about $1,600 a month in child support. Mr. Buckley is requesting that be lowered somewhat, given some changes in overtime insurance payments, etc. What I'm going to do. So this is going to be a 3-month order. I'm going to impose whole family support for 3 months. We'll start that June 1st. And in the amount of $2,200 a month. After that, my hope would be that we'd have all the information necessary to run child support. And after those 3 months, we would revert back to either an agreed child support amount, or we'll set a hearing and I will set child support at that point, allowing Mr. Buckley an opportunity to submit what he believes are new numbers to the state. Did I miss anything?
I want to make sure that the family support is paid through the registry with DCS.
So if your honor's adopting my order, I did include that language in there. That support would be paid through.
In the family law order, it does say payment of any payments made through the Washington State Support Registry Child Support Division.
Perfect. Thank you.
All right. Thank you.
And then would your honor just indicate reserved, because obviously my client's request was that be backdated to the time data separation November. So will you just reserve on the period of November to June?
Is there a good place for me to do that in here, or shall I just write it in somewhere?
You probably just write it below, right above the payment method registry, just a little one line there.
Okay, so what I included under section 5 of the temporary family law order is erase the spousal and included and put in family. So respondent must pay family support to spouse. The income is the income amount, $2,200 a month for 3 months of whole family support to begin 6/1/23. Any back child support is reserved. And then that's the only order I'm entering, since sounds like my hope is that the parties can figure out a parenting plan. If not, the 20th is, I have plenty of spots on the 20th. If you want to come back in 2 weeks, if that hasn't been worked out.
We can do the 20th, Your Honor. And I know that you've made your ruling, but my client indicates to me, and I'm looking at his pay stubs, that's the family support is basically one of his checks per month, and he's extremely concerned. He simply can't afford that. So I don't know if the court can revisit that, or we'll have to see what happens.
Could the court set a child support review hearing for August 15th, since the 3 months will be up in August?
August 15th, 2023 at 1 p.m. I'll set a review for child support.
Your Honor, would the court reconsider the $22 a month?
I'm looking at, I mean,
Apologize.
he's making $96,000 a year.
Yeah, I'm looking at his pay stubs, and because there's 100 and change that goes to the loan that was taken out during the mortgage that reduces his paycheck. His net pay for pay date January 27th for that 2-week period was $1,800. Net pay for the month the check after that was $2,019 so his net pay, when you look at all the deductions, and then the next one is $1,984. And the next one was $3,300, but that was a significant overtime he got 20 hours of unscheduled overtime to get to 33, then ending March 24th, 22. So he's really taking home in the low, around 2,000, 20-something hundred, twice a month.
I mean, to be frank, it's not much more than what likely child support's going to be for 3 months. I'm going to order the $2,200 a month for 3 months, beginning this month. So it may be very difficult, and I really understand that, but it's temporary. So
understood.
I'll get that temporary family law order entered, and then my hope is on the 20th, and I'm assuming we want to set it for the 20th just to ensure that, okay, we'll set this to the 20th. If we have agreed orders, wonderful. If we do not, then we will get it sorted out, and I will double check Mr. Roberts to make sure I don't have a bench copy that is color around here. So,
Okay.
or if you want to email it to me, I'm happy to look at it that way. So I have it ready to go for the
Sure. I can do that. Just include everybody on it soon.
Perfect.
Fine. I'm sorry about that.
No worries. Thank you. And I have
Very good. Thank you, Judge.
just so
All right.
Thank you,
thank you.
everybody.
Miss McLean's proposed that she signed off on the 31st of May. So your objections were based on that order, correct, Ms. Baldwin?
That is my understanding.
Okay, I have notes on all of it, so I'm ready.
Okay, so I did file my objections. So pretty straightforward. The first is because the guardian ad litem, this is a final report. There shouldn't be a continuing sort of availability at whim to order more evaluations. So that language should be stricken. The language on page 4 at when school, essentially what to do if there's no school, which would include the summer months that are all coming up. To me, it should be released to father at 2 p.m. or when school releases. So if there's no school, dad can pick up early at 2 o'clock or make the appropriate arrangements. In summer, we had a specific argument about the summer holidays or sort of extended summer time, but we only really talked about father's time. We didn't talk about mother's time, to my recollection. I'm asking that the court make mother's time and father's time the same. The concern is, as written, mother has 2 weeks. She can schedule those over the father's weeks. That can be very disruptive when we're trying to create sort of a solid pattern for both parents and expanding time for both parents. And so in this case, sauce for the goose should be sauce for the gander. Neither should be scheduling over sort of the other parent's time in order to make those sort of extended weekend periods. In regards to 3-day weekends, we spoke a little bit about those when we argued. I'm just asking that it's clear that it's not just Monday holidays, it's Friday holidays as well, and service days. And then that would mean pick up and drop off on Thursday or Monday as is appropriate. And then transportation language just needs to include that my client can pick up directly from school on Wednesdays. If he's going to be picking up this court order, even if you didn't make any changes, would have him picking up at 2:15 when school releases on Wednesdays. He needs no one's meeting in a parking lot at 2:15 other than the school parking lot. So it should allow him to pick up directly. Those are my requests.
Ms. McLean?
Thank you. So first off, in regards to the request at paragraph 4B, I guess I'll leave that up to the court's discretion. That was the language that was previously adopted by the court. I understand that Ms. Height hasn't necessarily made any recommendations, but she has also left a lot for the court and or counsel for us to try and work things out. And as was indicated at the hearing, I hadn't even received this evaluation, this domestic violence evaluation, until after we were in our last hearing that I received from Ms. Height as to Mr. Kaufman's domestic violence evaluation. So I think it would be appropriate, if anything, you keep that as reserved. In regards to the Wednesday visits at paragraph 8B2, first off, we had the discussion on the record about my client's work schedule. If you recall, I asked if she could pipe in and she gave us the thumbs up that she could meet by 4 p.m. And that was with reference to the Friday exchanges. So she can accommodate 4 p.m. exchanges at Friday. My client works in Rainier. I'm not aware that my client can accommodate an every Wednesday 2 p.m. exchange during the summer. So our proposal is that you leave that at Wednesdays at 4 p.m. In addition, if you go back and look at Mr. Kaufman's proposed parenting plan that he filed back on December 2nd of 2022, you will see that at that time, his own proposal was that he should have the second and fourth Wednesdays from after school or 3:30 p.m. if no school. So our position is that you keep the time consistent with 4 p.m. exchange on Wednesdays if there's no school. And again, keep providing some priority to the fact that my client is still trying to maintain employment. And if there's these ongoing consistent interruptions to her expected work time, that doesn't bode well in the future. Parents' work schedules have to be given some credence when we're crafting parenting plans. So we're asking that you maintain that at 4 p.m. if there's no school. In regards to paragraph 9A, first off, I agree that we technically did not discuss my client having vacation time. I have proposed he's been allowed 3-4 day visits in conjunction with his weekends, or if they can be scheduled at some other time such that they don't interrupt my client's weekends. The language that I proposed would allow my client to exercise 2 summer vacations, not to interfere with his weekends, they would include her weekend, but it would allow her to interfere with one of his Wednesdays. So each 2-week vacation would interfere with one of his 3-day or 3-hour Wednesday visits. I don't see that as unreasonable, considering that she's been the primary parent. There hasn't been any suggestions or recommendations that my client has any 191 factors. My client hasn't been admonished by this court for her behavior directed towards Mr. Kaufman. So again, my client should be allowed to have some extended residential time in the summer with her children. If you read the language at paragraph 9A, it says specifically that she'd be allowed to exercise 2 weeks of uninterrupted by the father's Wednesday's visits. In other words, that's the only thing that she would be removing would be the Wednesday visit, and that she's to provide 2 weeks notice too. So we believe that that's appropriate and ask that the court adopt that. In regards to paragraph 10 on the Monday and Friday, the suggestion as far as Monday and Friday holidays. First off, again, if you go back to Mr. Kaufman's proposed parenting plan that was filed on December 2nd of 2022, his specific language is the exact language that I adopted. If you go back and look at my clients, any of my clients' proposed parenting plans, my language, my format language is different. I adopted Ms. Baldwin's own client's language relative to 3-day weekends. And so we're asking that the court maintain that. That was what the court had ordered in my estimation. In regards to the transportation issue, the transportation language, so if you look at the bottom of page 5, paragraph 12A, it says that the children will be exchanged for parenting time, picked up and dropped off at school when in session. So that allows him to pick up at school when that's in session, and when he's supposed to pick up when his actual time says that it either starts or ends, starts after school, from school, or ends at school. So he's to provide that transportation during his residential time. Otherwise, if it's a non-school day, paragraph B says it's to take place with the exchange occurring at the Fred Meyer Shopping Center on Ocean Beach Highway when a parent is not picking up from or dropping off to school. So that language is reinforced. So I'm not exactly certain what the objection is. If you turn to the next page at the top of paragraph A, again talks about at the very end of that, or the second sentence, it says, if a parent's time starts at the time school ends, or if a parent's time ends at the time school starts, then the parent exercising visitation shall arrange to pick up and or deliver the children from and to school. That provides for that exchange. If school is not a factor, then they have to do the exchange at Fred Meyer parking lot. So I don't understand what council's objection is to the language that's been provided.
All right. Anything else?
No.
Your Honor, might I weigh in just briefly?
Sure.
A problem that I did not foresee at the time I wrote that report is that the Rainier Bridge repair is going to muddle mom's trips back and forth, and we don't know how bad that's going to be or for how long. I know personally, even recently, getting across that bridge has been nightmarish at times. And it seems like it could add a lot of stress, a lot of times through the summer, trying to meet deadlines. And I don't know if this is even appropriate or possible. If mom has difficulty getting across the bridge or making that time, there could be another party that would help with those exchanges with the kiddos. I can just imagine it being a big headache at times during the summer, and wondered if there could be a plan B in place.
Well, the proposed parenting plan, again, at the second paragraph A at the top of page 6, provides the parents or their designees. It's unreasonable to, in my opinion, to rely or demand that a designee be present to provide transportation every Wednesday at 2 p.m. if my client is at work. And I believe that the bridge closure, isn't that only for a week?
Well, there's been a series of repairs going on right now, and so it has been a mess many days. And I don't want to create a problem where there isn't one, and I don't know if it would matter as far as time goes or not. I'm not really suggesting a change in anybody's proposal for time. I'm just acknowledging that could be a problem down the road. And if there's a designee involved for those particular times, I'm fine with that. I guess I was just borrowing trouble.
I think the language already does provide for designees. So,
brief rebuttal. So I think the guardian line was just trying to be helpful and trying to solve problems that she anticipates, and I understand that. When it comes to evaluations, again, this is a final report. It shouldn't just, the door shouldn't always be left open. When it comes to the release time, arguably 4 makes it worse. I would argue that it makes more sense that my client is picking up at school on Wednesday early releases, and that we maintain that throughout the summer. That's all my client is asking for. And this like, hey, gee, before they asked in this other plan, yeah, and in that other plan, my client was getting extended weekends from Friday to Monday, and there was a whole bunch of other things that my client was getting. When you're not getting those things, you're looking to make sure that you have enough time, and also to make these exchanges as easy as possible. Again, for the summer, makes sense. I understand the need to potentially eliminate a Wednesday visit. But my client's weekends shouldn't be interfered with. The order as proposed doesn't exactly say that. It just says that she can eliminate his Wednesdays. It doesn't say she cannot eliminate his weekends. So it just depends on how you find reading of that language. Again, the Friday and Monday holidays, there's really no reason not to include those. It's just sort of trying to eliminate opportunities for my client to have those 3-day weekends. Transportation language, again, I'm just looking to shore it up so there's no misunderstandings as to my client being able to pick up directly from school on an early release, and making it clear that it's whatever time the court designates when school isn't in session.
On the Wednesday afternoon, during summer, are the kids going to be in a I mean, where are they going to be, and why does mom need to be present in order for dad to pick them up at whatever time on Wednesday in the summer?
I don't know what the plan is for the summer for them. All I know is that when they are, my client has been the one to provide that transportation exchange. Obviously, Mr. Kaufman works as well. And so that, I mean, that 3:30 time was originally what he had proposed in his own parenting plan. I assume because that's a function of his work time. He historically has not picked the girls up from school prior to this action.
I mean, those are the same arguments though. Prior to this action, everybody's schedule was different. No one's in the same position they were when these parties were married.
And I'm assuming 2 o'clock works, 4 o'clock works for your client, Ms. Baldwin, and he will take as much as he can get. Is that fair?
Yes,
Okay.
that is fair.
And I guess just off the cuff, do either counsel have any concerns with mom not being present for a pickup of kids on a Wednesday?
No.
No, other than the question is whether or not you're going to then make somebody else have to be relied upon to do that when this is a parenting function. And the difficulty as far as scheduling third parties and having somebody that's there all the time is the only question.
Well, I guess I don't know why that's necessary. If the kids are at home, mom's at work during summer, dad can go to the home, kids can come out of the house.
Dad cannot go to home. That's why we've got the exchange occurring at Fred Meyer.
So I thought it was just a restraining order with her. And I'm assuming it probably does list the house, doesn't it?
Yeah.
I'm going to recall though the specifics, because I don't recall that the court has an in the box order on this case though. I think this is just a garden variety type of stay away order, because the court specifically, she asked for that restraining order and the court largely denied it. And I think denied it outright. So I don't think that there is one. I think the court gave her possession.
The court also recognized the difficulty and at least the argument of Mr. Kaufman's self-help at my client's residence and the difficulty that caused for the youngest child as well as my client, as well as the ongoing behavior even in the public location at Fred Meyer. And our position would be that visitation exchanges should continue at a neutral location, not at my client's residence, because that has been fuel for him to engage inappropriately with my client.
But if she's not there, it's not a problem. And this isn't the community home anymore. The community home's been sold. There wasn't a restraining order entered. So
Well,
the idea that, like, we can say curbside.
There's a temporary restraining order from 11/28/22. I don't see anything post that has changed. And that order does indicate restrained person must not go onto the grounds of or enter a protected person's home, workplace, vehicle, school, or daycare of any child listed, and then not knowingly go or stay within 1,000 feet of protected person's home, workplace, vehicle. Has that been changed at all?
No, I don't believe so.
No, but then we had a hearing, I swear that was in December, where then we had a full hearing after the court looked at the police reports and everything associated with it. So now I'd need to go back and look.
There's on 12/6/22, we had a hearing on an order shortening time. That was a temporary restraining order that I just reviewed. Court here's the restraining order. Court denies restraining order.
Yeah, that's what I recall happening. So I think that there is a subsequent order where, well, obviously there's an oral order. We can find the paper order that you denied that. I don't mind having an order that's like curbside, like these are kids that are old enough to have phones. You know, my client can pull up curbside. It's not going to go in, you know, not even knock on the door if that's what the court wants. But again, if mom's not there, it seems weird that we're choosing a situation where we're forcing mom and dad to meet directly over a situation where we're basically ensuring that they don't meet directly.
Well, I think, again, you're putting the children potentially in the middle. As far as if dad decides.
I don't buy that at all. I mean, every time that a parent exchanged with another parent, the kids are in the middle. I mean, let's be honest. There's not, I mean, if they're not ready on time, I mean, that kind of thing. But I don't know. I don't, these are pretty, I want to think they're almost a 14 and a 9-year-old, and we've already had a lot of visitations. I'm really not that concerned about it. There is no restraining order. And I'm glad that we reviewed that and looked at it, because yeah, it appears that in December that was denied, and that was just a temporary order that was in place for, it doesn't even look like a month.
It is. I did find the order terminating. Order terminating is December 16th.
So here's what I'm gonna say. I'm gonna change it to 3:30 p.m. if no school. So during the summer, clearly if the kids are in summer camp or, you know, like some other activity, then obviously dad should know where to go. And I already ordered that that whatever activities they're in should be prioritized.
Yeah.
As for 9A, I think I agree with everybody. We didn't really address it. I think it's appropriate to allow mom to have that time. So I'm going to adopt Ms. McLean's proposed language. However, I did just add in, just to make it clear, mother's vacation shall not disrupt father's weekends. And I think that was probably the intent, but it wasn't super clear. So now hopefully it will be clear. I just interlineated school holidays, which fall on Monday or Friday, shall attach to parents' residential weekend, and the exchange shall occur Monday at regular scheduled time. And Ms. Baldwin, are you okay with me indicating that it was approved via Zoom?
Yes, with one question. What did the court do with the language at the top of page 3 regarding it?
I lined that out, so I omitted that.
Very good. You can write.
I did that, and I didn't say anything to anybody. I apologize. Okay, I will get those entered as soon as we are.
Presentation. My biggest issue is how the orders are framed, and so I didn't put in a formal objection because the orders are framed in a temporary order, but from the looks of them, then they're sort of unenforceable in the sense that if they were phrased in a child support order, that would go to the Division of Child Support and then be enforceable through a wage garnishment. And instead they're in a temporary order, which won't go to the Division of Child Support and won't be enforceable. And so it sort of depends on what Your Honor intended. We're also in front of you for a review. That's probably a substantive review. And so given that, if the court could give us direction as to sort of what you really intended, then I'd ask that we just set that presentation over and I can sort of react accordingly to whatever we present for today, based on whatever you order today.
Well, it would have been nice to have heard this prior to today so that counsel and I could have talked about this. Right now, as I understand Your Honor's order, you're reviewing financials at every one of these review orders, and the expectation is that the family support, or at least the spousal maintenance portion, the $1,100 a month of the family support, is going to be going away relatively soon, given the fact that this is a short-term marriage. Your Honor ordered family support. There was no indication that that necessarily was to be enforced through WSSR. The suggestion that this order, if Your Honor signs it and enters it with the court, is not enforceable is not accurate. Obviously, this court has the ability to enforce their own orders. Certainly, if my client hasn't been forwarding payments to Ms. Wishart by the 25th of each month, then that's information that I'm going to be hearing from Ms. Baldwin, and I will be talking to my client. But it's not, I guess, typically family support isn't something that we normally run through WSSR. And I think even on the case that preceded the Kaufman matter, it was Ms. Powers who asked that those payments go through solely because of that person receiving TANF. Ms. Wishart doesn't receive TANF in this case. So you specifically indicated you were not entering a child support order, you were entering a family support obligation. So if you want to add language as far as WSSR enforcement, I suppose that we could do that, but it's going to be so short-lived. I guess if I were Ms. Wishart, why would I want to have to pay, what is it, a $55 fee for WSSR to collect if it's going to be such a short period of time? And if it's obviously enforceable and counsel and I communicate on a daily basis?
So it's not true in the sense that $50 is pretty cheap in comparison to the fees for a contempt. And similarly, having something automatically deducted out of somebody's paycheck is pretty easy compared to spending $300, $400 per hour with Ms. McLean and I sending letters back and forth versus the Division of Child Support just taking it directly out of her check. And it isn't as if child support is going to go away tomorrow or next month. That's going to be an ongoing obligation. So it's not as if that $50 is just to secure, which is cheap, is just to secure a month or 2 or 6 months of obligation. It secures an entire year because, again, it's paying to secure the child support order. The court did give us incomes on what you sort of based your information on and the health insurance credits. So that looks a lot like, to me, like child support worksheet is what the court intended to have happen. So again, that's sort of my inherent concern.
And I guess procedurally, I'm wondering why we're arguing this when there haven't been formal objections filed. And my orders were submitted, 12 days ago?
Because I'm seeking clarification.
I guess I understand the concern. I understand wanting that clarification. And I get both sides' arguments. I think you both do that very well. Make your points, and I see it both ways. I think a lot of times it's a personal preference of attorneys on how they submit the orders or what they request. I just kind of quickly went through, and it's kind of 50-50 on temporary orders if the state registry is involved or if they're not involved. My hope would be that we're not here on contempts for failure to pay. We have a gainfully employed individual that's been ordered support. So if there is no other objections besides that, I'm inclined to enter the order as presented. So I guess I'd want to know if there's any other concerns that you have, Ms. Baldwin, with the proposed temporary family law order.
No, I didn't have any substantive objections other than probably some wordsmithing things that Ms. McLean and I go back and forth on probably every time.
All right. And then I guess the remainder of these orders, I'm assuming, do we want to hold off on the parenting plan, but I can enter the child support and child support worksheets, assuming there's no other issues there?
There is no child support order or worksheet.
It's just the temporary order.
It's just the temporary order. Again, at paragraph 5, you provided for family support.
They were in my packet. So I was just going through what was in the packet.
No, those would have been my original proposed temporary orders from our hearing a couple of weeks ago.
Oh, well, they clipped them all together. So then they just take me out, I guess. So the temporary family law order and the parenting plan are all that we're worried about today.
Yes, and you should have a temporary family law order that I signed as of May 25th of 23.
That is what I have.
Okay. And so at the top of that page, you should have health insurance of $538.71, and then the attorney fees of $2,500 at paragraph 12. Yeah, that's the correct temporary order.
That's what I'm looking at.
Okay. Approved via Zoom for you, Ms. Baldwin. Okay.
That's fine.
All right. So I obviously have read the most recent declarations, and I have the parenting plan here. So I'm assuming we want to just kind of discuss those.
As far as the review hearing?
Yes.
Sure. So first off, I will tell the court that Mr. Wishart, the day of the hearing, I reached out to Ms. Lovely. The earliest that she could schedule Mr. Wishart for a domestic violence evaluation was June 16 at 10 a.m. He is scheduled for that. Ms. Lovely has been provided the contact information for Ms. Wishart, Ms. Baldwin, and Ms. Kale, the GAL. and she's been instructed to receive collateral information from Ms. Wishart and Ms. Kale. Mr. Wishart, in light of the drug test results, has a drug evaluation scheduled with Awakenings on June 13th of 23 at 2 p.m. He's been instructed to ask them to, or to instruct them to contact both Ms. Wishart and Ms. Kale for collateral input. As my client tells you in his reply declaration, he does acknowledge using the drug that he tested positive for. I think it is appropriate to note that he did not test positive for any of the drugs claimed by Ms. Wishart. We propose in regards to the drug testing fee that not be reimbursed. First off, Mr. Wishart, once we can get visitation scheduled, I mean, here we've been another 2 weeks without any contact with his child. Once those are arranged, and we're just waiting for scheduling that with Ms. Fellows's agency that coordinates with my client's time off. He unfortunately in the interim had a mandatory change in his schedule by his supervisor. I can't tell the court as I sit here exactly what that was for, but as soon as I got that notice, I provided that to Ms. Baldwin and to Ms. Fellows. And so the hope is that we're going to have visitation, I believe, arranged for this week. Professionally supervised visits through that agency are $40 an hour. And Your Honor has ordered supervised visitation 4 hours a week. That means you're looking at $160 a week, or essentially $693 a month for professionally supervised visitation. So as it relates to that visitation, Your Honor—
Didn't I authorize a third party?
Yeah, you did, but we weren't able to work that out. Ms. Baldwin sent me a list of 10 individuals. I sent her a list of 13 individuals. We had agreed for my client to have visitation supervised the weekend after so we were in court. I have to look at a calendar, I apologize. We were in court on the 19th. Yes, we had arranged and agreed to Clay, Ms. Wishart's brother, supervising visitation the weekend of May 26th. And then we were told on Monday, the 22nd, because my client wouldn't agree to her visitation demands, that even though he had agreed to Clay, that now because we weren't able to work it out by that Friday, even though he agreed to Clay doing the supervision the next weekend, that because you ordered that if we hadn't worked it out by Monday, the 22nd, you were ordering professionally supervised visitation. And so I'd even received an email from Ms. Baldwin that said, my client will pick one of your lay supervisors to supervise, then we'll do a professional supervise, and then you pick one of our lay supervisors to supervise. But all of that was removed and off the board. Even though we agreed to all of that, it was removed and off the board because Monday hit. Your Honor said that it had to be professionally supervised if we couldn't agree by that date. And even though we had agreed to Clay for that following weekend, all of a sudden Clay was no longer available to provide supervised visitation. So here we are 18 days later, and my client has had absolutely no contact with his child. And I've done the best that I can as far as communicating and trying to coordinate. My client has asked for that visitation. He agreed to Clay. We were then told Clay couldn't do it or wasn't available. And therefore, as of the 22nd, because Your Honor said, if we couldn't work it out with lay supervisors by then, it had to be supervised. That's what they chose. And then we had, obviously, trying to work into a professional facility where my client's 4 on, 4 off. And then we had this unanticipated shift change for a short period of time for my client. And so the facility hasn't been able to get him in. I can go back to my emails, and I'm sorry, I didn't get that in my notes. I know that there is, actually, I think I have it. So the email from Ms. Fellows to us last Wednesday was, so originally my client's first visit was scheduled for the 30th of May. However, his work schedule changed and had to be canceled. He did have availability on Sunday and Monday, but we were closed due to the holiday because that was Memorial Day weekend. His first visits are next week on Tuesday. So he must have had a visit today from 10 a.m. to 12 noon. And then he's supposed to have a visit this Thursday from 11 a.m. to 1 p.m. So we've gone 18 days without visitation. So we have absolutely no objection to the court ordering forward-looking drug testing. We agree to loser pays. We have a limit now on what that drug is. So we know that if he tests positive for that in the future, and if the amount is less then clearly he's on a decline. I don't know how long that stays in your system as far as hair follicle for metabolizing. You can certainly see that it wasn't in his UA, although I guess maybe I should ratchet that one back. I think that they only tested for kratom, even though the court didn't order a UA. You ordered a hair follicle, but my client participated in it, and he was negative for kratom. So I don't recall. I think that's the only drug that they tested on the UA. So I don't have. I'm sure Your Honor knows more than I do as it relates to how long it takes for hair to metastasize or metabolize, not metastasize, metabolize that drug. I don't know the answer as I sit here. Obviously, a UA would show up to 72 hours. And typically that stays in the system for up to 72 hours. I don't know how long it's in your hair. So that's the one issue that I don't know. As it relates to, the financial review, obviously my client's net is $5,698. We've got him paying $2,000 a month in family support, paying her car at $325 a month, her automobile insurance, which she unilaterally, before this case was even filed, removed her automobile from the joint automobile insurance, an automobile insurance bill from counsel. So my client doesn't have anything that he can pay at this point for that, as you ordered him to pay the automobile insurance for her as well. I'm assuming that's going to be around at least $75 a month. He also pays for health insurance, which is $213.08. So that's a benefit. All of those are a total benefit to her of $2,613.08. The court has ordered him to pay his vehicle of $526 a month, his vehicle insurance of $75 a month, Addison's health insurance, as well as his health insurance, which is $325.63 a month. So that total for his benefit and Addison's benefit is $926.63. Assuming that we're continuing down the path of professional supervised visitation, that's going to be $693 a month. He also this month has outlays for the domestic violence evaluation of $550, not including any treatment that might be recommended if that is ordered by the court. The substance evaluation will be approximately $200 if it's not covered by his insurance, and I don't anticipate that it would be covered by his insurance. Plus, there would be costs for treatment if it is determined that treatment is necessary and if this court orders that. So just for those evaluations and the supervised visitation is another $1,443 per month. In the future, it would be the $693 for professionally supervised visits, plus any services that he's ordered to go through. My client is currently scheduled to take the high conflict children in the middle parenting seminar. As soon as he's completed that, that will be filed with the court. So right now, after all of those expenses, that leaves him with $715.29. And we haven't even gotten to his personal expenditures, such as fuel to go back and forth to Kalama for work, food, personal expenses. I mean, none of that has been covered. Self-support reserve, 125% of poverty level, I believe, is $1,415 a month. So he's clearly well below the self-support reserve based on this order. Our position is that if the court is going to maintain this family support, that you, again, terminate that after at least, I would say at most, 3 months, because this is a short-term marriage. At this juncture, we have absolutely no information or proof of Ms. Wishart's efforts at securing any type of employment, even though she's living with her folks and has the ability to go and do that. She has provided absolutely no information of employment searches, and the court should be imputing at least minimum wage to her in regards to that, and considering that in reference to how long this spousal support portion of this family support should continue. So we're asking that the court provide relief that the spousal maintenance, the $1,100 a month, would terminate after 3 months. I think we made that effective in the temporary order as of May 19. Yeah, as of May 19. So it should terminate as of August, let's see, June, July. So terminate after July 19th. So he would be done as of August 18th of 2023. And again, keep in mind that we've got these additional expenses relative to services. One that Ms. Wishart wants him to participate in, and we anticipate that the court the court has already ordered the domestic violence evaluation. So those expenses are to be taken into consideration by the court as well. Keep in mind also that Ms. Wishard again removed the majority of the, I guess it was 2/3 compared to 1/3 of savings that these parties had. And the court has also ordered that my client contribute $2,500 towards her attorney's fees. So he doesn't have a tree that grows money. And he is in a new position that he trained for at the commencement of this year with his job. He's low man on the totem pole, so he would be the last man that would qualify for overtime. And at this point, he's hamstrung as far as his abilities to provide financially for all of these things that the court is ordering.
Quick question.
Yes.
I always think that I'm saying something that's kind of lays out my position. Clearly, it sounds like there at one point anyway was an agreement that Clay Lindbergh would be agreed by both parties. Is that still the case?
I have no idea. They retracted.
So we agreed, they asked over Memorial Day weekend. It was the holiday weekend, so people have plans far in advance. But going forward, that certainly would be an agreement.
And I would ask the court to give me an opportunity to go back and look at emails, because I think that was their offer, and we agreed to, but I don't want to misspeak. So if you would bear with me for just 1 minute.
Right. And I can explain in my argument additionally.
So the email from Ms. Baldwin's office was, we've not heard back regarding our proposal yesterday afternoon, which they had. With the change of your client's scheduling changing, our client's person, Clay Lindbergh, is not available to supervise for too long, and Mr. Wishard needs to have visits with the child. So they withdrew that. It says, as such, our client already paid the registration fee with Beth Fellows' office, so she would like to just move forward with the visits with Beth Fellows, and that was on Monday, the 26th.
Okay. And so he's had at least one visit with the child
Today. And I guess if Jonathan, if you could just turn your video on and give us the thumbs up if that's accurate that you had a visit today. Okay, thank you. So he's had 1 2-hour visit today. Thanks.
And but it sounds as though, barring scheduling, unprofessionalized, both parties would agree to Clay Lindbergh. Correct? Okay. Obviously, that's really good to know. I don't know. I'm not going to sit here and dictate when things are going to necessarily happen, but that's obviously a good resource to have if there's a mutual person that's willing and able to do that within their schedule.
And just so the court knows, Ms. Baldwin had a list of 10 people. We had a list of 13 people. No response as it relates to any of the 13 people on our side.
Okay. All right, Ms. Baldwin.
Thank you. So we have to pause here and remember where we were at the time of the court's last order. At the time the court made its last order, Mr. Wishard denied all substance use, denied all problems, said there were no issues, but thus far, at the time that you had last seen him, also refused to take a hair follicle until you ordered it, even though it had been sitting there. And these people were not people who just broke up yesterday. These are people who had been separated since March. So we have March, April, May, when he's doing his drug test, we're about 3 months in. And that would be 3 months where you know you're going to get into litigation. You know you're going to be under the court spotlight. You know, the minute you meet with your attorney is not the minute that your court documents are filed. There's gaps of time there. Mr. Wishard had time to get clean and he could not do it in that amount of time. Then coming to the court and sort of claiming innocence, knowing the entire time that he had used and was not honest with the court about that. It's important to keep that in mind. And especially when we're thinking about the veracity of his statements and the integrity of his statements sort of throughout, is if he's going to lie about one thing, it's going to happen about other things. And so when my client testifies, she says, look, the only things that I'm accusing him of having used are the things he told me he used or I saw him use directly. And those were not only the cocaine that we now know he's positive for, but Oxycontin, Suboxone, fentanyl, alcohol, and marijuana. That's a large list that is important that we keep that in mind. And my client says this is not a one-time thing. And even Mr. Wishard admits that his substance abuse goes back at this point several years. He's never received treatment before today. and yet again denied to the court his use and the fact that he'd be dirty. The first thing that's important, the court should order the refund of the testing amount. The only reason we had to do testing is because Mr. Wishart wasn't honest. It's ridiculous to say that that shouldn't be paid for out of his pocket when the only reason it had to be done was the fact that he was dishonest with the court. So the court should order that to be paid. The court should order him to comply, because it hasn't yet, with completing substance use evaluation. It sounds like that's getting on board, and that's great, but we should make that an affirmative order so that there's no backing away from it later. The court should make findings in a parenting plan under Section 3A regarding domestic violence. In this case, we have photos of holes in walls. We have texts where he admits to his behavior, apologizes for it, blames her for it, sort of apologizes again, that cycle of violence. We see the financial control that is, again, kind of a hallmark of domestic violence. And we have my client talking about the violence that was present in the home that qualifies per statute as domestic violence. We should make that finding in this case. Similarly, you should make a finding at 3B for substance use disorder as to Mr. Wishart. The court should outline the limits and treatment. I'm asking that the court look at my proposed parenting plan filed on May 2nd. In that order, it makes the findings of domestic violence and substance abuse, limits his use further, so essentially that he's not to use substances going forward. I'm fine that there's a joint prohibition on corporal punishment of the child. He shouldn't drive if he doesn't have a valid driver's license, and he should not use any substance, including vapes or cigarettes, whenever he's around the child. Again, it sounds like we have the evaluation started, as I've outlined already. On a temporary basis, the mother should be the one who's making decisions for this child. That's what makes sense. Mother is not only historically the primary parent, it's required if there's a DV finding. And in this case, Mr. Statement is, you noticed in his pleadings, he says, I'm flexible, I'm reducing my work hours, but then he had scheduled supervised visits and then didn't do them because he went to work instead. So again, what we see is that 60-hour work week that he testified to, or I shouldn't say testified to, that are in his stated text messages to my client, which he doesn't deny, 60-hour work week's continuing. So that means his base salary is not his actual income. We have significantly more income. So then where do we go as far as the parenting plan? The parenting plan where the court had concerns about substance use should not be the same parenting plan that gets entered when we know that there is substance use. One is a concern and one is a varied. And so we now have the varied. We now have that we know absolutely that he has a substance use problem. And again, from materials and his own text messages, we see the domestic violence problem as well. My client would ask that until he can get clean, at least get 90 days without having used, that we limit visitation to essentially video visits, that we have a set video visit with him. That's not ideal. But the reality is that Mr. Wishart needs to get clean and needs to be motivated to. It shouldn't just be a struggle, oh, you caught me red-handed, and that there's no consequence to that, because there's real consequences to children being involved with folks who aren't clean and sober. So we are asking the court limit his visits to a video visit. Those could be once a week, twice a week, but it should be a reasonable amount for a reasonable duration, given this is a pretty young child. Thereafter, my client's preference is professionally supervised visitation, at least for a period of time, so that we can have a consistent view, and that we don't have he said, she said, his family, her family, sort of making statements as far as, visits are going great or visits are going terrible. I think it is helpful to have at least a brief period of professionally supervised visits, since you do get the benefit of having those notes that come along with them. So my client is asking for him to be clean and sober, then move into a brief period of having professionally supervised, and then ideally family supervised visits. But again, there's a relatively short period of time between now and when we're back in court in about a month. So the court can either make a fully fleshed out order, or you can make an order to sort of an additional interim order to get us to the next review, when you'll potentially have evaluations to go off of and have a better idea of sort of where to go forward. Ms. Lovely, I found, is fairly efficient if other people are efficient in providing the requested materials to her. So I find that what delays her evaluation is not her, but really the people who provide the materials to her. And I know my client will be prepared to do that quickly. So we're asking the court to think carefully on the visits, especially where Mr. Wishart has not been honest with the court, isn't clean now, and doesn't have any treatment on board to maintain his sobriety. That's unfortunate, but I think that's where we are. If the court is going to, and I do want to briefly talk about visits. I think counsel makes a significant effort to sort of blame my client. The reality is here, my client, and she provided you a declaration and text messages where she offered, we had our hearing on the 19th. She offered visits that weekend. He said, no, I want it my way or the highway. She then said, okay, I can get visits going with a supervision place down in Vancouver. He said, no. then offered, okay, fine, we'll get him going with Beth Fellows. But Beth wasn't available to the following week. Those were scheduled. He then unscheduled them because he decided to go to work instead. My client offered a list of 10 people. He said, fine, I'll take that one over the Memorial Day holiday. My client said, well, that is Memorial Day holiday. He's not available. He's already made plans. Again, the supervisors are people too. They're not instantly available if you say, oh, I can't do it then, but now I want to move it to tomorrow. These are humans who have their own work schedules. So it isn't as if these people are available at the drop of the hat. They need to be scheduled. Finally, he scheduled, Bethel's was available 1, 2, 3 days. He canceled or wasn't willing to schedule any of those. He finally scheduled for this week. My client basically said anytime, anywhere, any supervisor that was a professional one or with Clay. But again, if he cancels them, my client doesn't have any control over that. And I think that speaks to the fact that he is working those 60-hour work weeks. That is his priority. I appreciate the work ethic, but sometimes kid schedule and supervisor schedule needs to come first. On finances, the court's basically already set Mr.'s income at essentially $5,700 per month. Again, the court's aware that my client's making zero. She was a stay-at-home parent. That is a ship that does not turn on a dime. It takes time. My client left school. She left prior sort of work-based efforts where she was moving forward in a career in the medical field. Again, that does not turn around instantly. The point, even in shorter marriages, and this is not a tiny marriage by any means, it's a shortish marriage, but not a marriage of 6 months. It takes time and there's supposed to be restorative maintenance to get my client back on track. The idea that we would cap it at this point, I think isn't reasonable. My client hasn't had a lot of time to get things back going. You'll notice that she's already done her parenting class. She's doing what she's supposed to be doing, looking into the schooling and getting back involved in school so she can get back on track and get her career back on track, which will only have positive benefits for the child. And ultimately, Mr. Wisher, when he pays less child support, because my client is making a decent wage in the future, instead of, sort of like, just go get any job, that's not a long-term benefit to the child. A lot of the costs council lays out are one-time costs, not recurring costs. Again, at $5,700 per month, he has no expenses. He's living at home with his parents. So he has very minimal outlays for his personal costs. So on a temporary basis, what I ask the court to do is maintain the current temporary order. We can review it again in July. Again, then we'll have more evaluations. You'll have hopefully an actual treatment plan and then real costs to base that on instead of just guessing at what those costs would be. And so then that would be a reasonable place to potentially reevaluate that. But again, the economic circumstances of my client is she has need, he has an ability to pay. And again, we were basically here just a few weeks ago in looking at this order. So financially, I think the court should leave the current temporary order in place. I think it's reasonable. It's puts both parties in a reasonable circumstance going forward. As far as parenting plan, again, we asked the court to adopt our temporary parenting plan that we filed or adopt a interim order that takes us to July when we can get further input from the guardian ad litem. But it isn't reasonable to trust the person who, when last before the court, wasn't honest with the court.
And thank you, Ms. McLean. Quick housekeeping matter before I forget. I know that when we set this, we set it for July 11th.
Yes.
And I am not here on July 11th, and I realize that probably wouldn't benefit anyone. So I know we don't have Ms. Kale here, but are the parties available the 18th?
Yes, I
will be more likely to have evaluations back.
I am out that week.
I could do the following week, the 25th.
I'm out the last 2 weeks of July.
Oh. With your honor's permission, we could move it to a Friday with your permission.
I don't have a problem with that. So I guess, Ms. McLean, are you out starting the 17th?
No, starting the 14th, which is Friday. And in the 7th, potentially I'm going to be on jury duty.
So August 1?
7th doesn't work for me. Okay. So that'll change a little bit what I do. Is August 1? I mean, I'm happy to leave it on the 11th. It won't be me.
And that's too hard. I just think any other judicial, there's too much history, especially when we're kind of doing orders like we are. I think it's too hard for somebody to come in and be a fresh slate.
I don't know. Judges do it all the time. That's why you have coverage. So, and clearly you've got all of the temporary orders in place.
Well, if the parties are fine, we'll just leave it on the 11th. And if for some reason that doesn't work out, then we'll do our best to schedule it as quickly as we can in front of me. Okay. That works for everyone. I just wanted to raise that issue because I know that I probably said it with the intention of me hearing it and not remembering that I'm going to be gone then.
And wait, before we move on from that, I would argue for it to be set over if we appear on the 11th. So are you ordering it just to go forward regardless? And then that's your order. Or are you just setting it and because I do think it should be, Your Honor. Just at this point, I've already got a ream of paper that the next person would have to arguably review.
And again, I mean, judicial officers review dockets, they prepare for these hearings. They'll have feedback from the guardian ad litem. You do this all the time.
And Your Honor,
I'm just thinking about the additional delay.
Yeah.
And I don't want my scheduled 2-week vacation to mean that my client's going to have to incur another, what, $100 or $300 and some in supervised visitation fees. Of which I will tell the court that my client let me know that it's not $40 an hour, it's $45 an hour with Ms. Fellows' agency. So that's $180 a week or $780 a month. Do you mind if I provide just some additional brief comments?
Well, I think I know what I'm going to do, and that may determine where the parties, that may change your position on whether the 11th is okay, or if the August 1st would be better.
And I guess the only other thing that I would say is that if we set this for August 1st, I don't know if I've not worked with Ms. Kale before, so I don't know if she plans on issuing a written report. I won't actually be back and be able to address that until the 31st. Technically, we've marked me out because I'll be trying to play catch up, having been gone for 18 days. But that's going to be my first day back in the office, which is the day before the hearing. So it's not like I'd be able to get anything substantive entered with the court before that hearing. If we're set to August 1st.
I don't want the whole order to be crafted around one of our vacations. Like that's also my concern.
Okay. No, we all have lives outside of this that we try to work with our clients and with our cases, and I understand that. So here's where I'm at. I'm going to just have a chat with you folks about what I'm thinking here. Clearly, the drug report was not great news for anybody. I know a fair amount about drugs and what's in your system. Looking at this, to me, just with my history as a practitioner, the numbers, 90 days probably would be my guess for how long cocaine would stay in a hair fall in your hair. Obviously, that can change depending on how long your hair is and how often you cut it. Additionally, the results, the numbers results, to me look really borderline between occasional use and what I would call is social use. So weekends, daily, potentially daily or a few times a week use. But I'm not going to really base anything on that, but that's concerning. Does that in and of itself show me that there's a history of substance abuse? Not necessarily, but it's concerning, given the type of accusations that have been outlined in the declarations that the courts received. Does that in and of itself make Mr. Wishard incapable of having a safe visit with his child? No, I don't think that it does. Clearly, we want to ensure that the child's safety is first and foremost. I think additionally, it is important to address any substance abuse concerns that exist here. So I am very glad to hear that Awakenings is scheduled for June 13th. I'm very glad that the DV evaluation is scheduled for June 16th. My hope is that we'll get, the Awakenings eval, he'll likely get an oral report the day of, and usually those don't take more than a few days to actually get back. With collateral input, that may add a few extra days, assuming there's no concerns getting a hold of everyone. DV evaluation, as Ms. Baldwin says, I agree with that. The collateral contact is probably the biggest delay. The financial situation, I'm not really making any changes with that. I do understand the concern with the order kind of saying, well, it's going to just keep being revisited. But at this point, I'm going to leave the whole family support as ordered, with, I guess, the caveat that I don't anticipate that being a long-term situation. But I'm not at this point willing to say that it's just going to be 3 months. So I would like that to be reviewed at our next hearing. As far as the parenting plan, I frankly think that we're in a situation where since we do have this hair follicle that came back the way that it did, I do want to see the evaluation from Awakenings, and I do want to see the domestic violence evaluation before I move beyond what I've ordered. So I am going to order that the visitation be supervised. I'm not ordering that it has to be professional supervision. I understand Ms. Baldwin's position and her client's position of wanting that and wanting like some kind of consistency in reporting, but I'm not going to require it be that. Obviously, it probably would be in Mr. Wishard's best interest to stay on the books at Ms. Fellow's place in case there's no availability for the unprofessional supervisor. But frankly, in the declarations and text messages, it looks as though Ms. Wishard has been trying to get visitation set up and trying to be proactive in that. The offer of meeting in the park with the child, which he declined, trying to get things set up. So I don't think, as long as Mr. Wishard's willing to work with folks' schedules, it sounds as though Ms. Wishard is willing to make that happen. So that's my hope. And if for some reason there are issues with that, then we have the professional supervisor as a backup.
May I ask a question?
Sure.
So is there any reason why we can't have one person from each side that's chosen so that we aren't burning out a supervisor and we can go back and forth, one with his, one with hers? And the other thing too is that Ms. Baldwin had made a comment about, you'll get the supervised visitation notes from the professional supervisor. I fully expect that the court's going to enter a lay supervision contract and that the lay supervisors are also going to be required to provide visitation notes.
We do have that form now that's signed by the supervisor that's agreed upon. So Mr. Lindbergh would essentially assert that he's going to follow the parameters of the court's order and report any issues along those lines. So I think it's like a 2-page form. So it sounds as though Clay Lindbergh is one approved individual. Frankly, I don't know, Ms. Baldwin, if the 13 folks that were sent to you, if there's any on that list that Ms. Wishard is willing to accept as an alternate individual.
Let me chat with my client about that, and I should have an answer hopefully momentarily.
Do you want a breakout room, or is she in your office, or?
If you could do a breakout room, actually, that would be great.
I can do that. Yeah, sure.
But she's okay with Christina Wishard providing supervision.
That's great. So now we have 2 options outside of the professional supervision. Obviously, I would just encourage the parties to have patience with those folks because their schedules and their lives are separate and distinct from what's going on in this case. And I appreciate that they're willing to help these folks out in this situation. So I don't think there's anything I missed unless either party has anything other than the date of review.
So if we work off of the parenting plan that you have in front of you, I do have the provision at paragraph 4B2 as it relates to the, that was your honor's prior ruling in regards to use.
I wouldn't agree to use that parenting plan. The parenting plan is reserving issues. It's reserving all the issues. And clearly that's not where we are anymore. It makes more sense to me that we enter something that actually either is an interim order that reflects what we've actually done or is a really stripped down parenting plan. Since we're going to be back to review in essentially a month or a month-ish.
Well, I understood that we were here, that you at your review would consider the input and make determinations after you get the evaluations. So
that's
did I
no, you didn't admit
that?
No, my thought at this point is that the status quo of supervised visitation is going to continue until our next review.
Okay.
And because I do want, sounds like everybody is engaged with the GAL or started that process. So we have the GAL, the Miss Lovely and Awakenings all on board. Those 3 things I think are going to be very important for the court to really move forward from there. So parenting plan is essentially Ms. Wishart is primary parent, Mr. Wishart, and if I think I said a minimum 4 hours a week.
Yes.
And if there's an agreement and availability for more time than that, and both parties agree, I'm happy with that. I'm not, but a minimum of 4 hours per week, and those evaluations taking place, 2 different supervisors that are available. And then we also have the professional, since he's already engaged with that. My hope would be that it wouldn't be as difficult to utilize them if that becomes an issue, but with 2 different folks available, my hope would be that Mr. Wishart wouldn't have to keep shelling out that money for professional supervision, since we have 2 folks that are willing to help out. So that's where I'm at.
So do you want to make interlineations on the parenting plan that's in front of you, or do you want a new parenting plan proposed? Because if you want to make changes, I'd like to just walk you through those.
And my preference is that we have an order that is an order on hearing.
And we're gonna, I think just a quick, dirty order, kind of maintaining what we're at is appropriate. We do have the temporary family law order to cover the other, other things.
Let me make sure that I understand what you're saying. So you don't want an actual parenting plan entered. You want just an order that says she's custodian. And I guess my only concern is I want to make sure that we've got the relocation statute identified in whatever order is being entered, which is why I prepared the parenting plan.
No, and I understand that. And I'm fine doing just a really pared down parenting plan, but I don't know that, frankly, that this one would be legible by the time I get done with it. So if the parties, if either one of you are willing to take on, because I would adopt the relocation and all the, the language, I guess I'm going to call it the standard language that we see kind of post section 13 and up. I would adopt all of that, and I think that's appropriate. Let's address the July 11th on Friday. If we can get, if Mr. Wishart's able to get visitations scheduled and, things are looking like he's gonna, then that may change positions, but I'll enter this order with the language that says July 11th is the next review. And then we can take that back up on the 9th.
So just to answer your question, I did talk to Ms. Lovely and let her know that our review was scheduled for July 11th and that you were anticipating having evaluations from her. She said, so long as she had timely contact from collaterals, and again, I provided all that contact information. I provided all of the preliminary declarations and opposing declarations to her so that she had that information. And she expected and hoped to provide a report prior to that hearing. I have not contacted Awakenings. My client contacted Awakenings directly. My historical work with them as far as working with opposing or collateral information is that usually they can turn it around within 2 weeks. So my assumption is that we should be able to get something by then.
And I anticipate, now that we know it's Ms. Lovely, my client will provide her information probably by the end of the week. We'll reach out to Ms. Lovely today. The only other thing that the court hasn't touched on is if you're ordering reimbursement for the drug test.
Yes.
Okay.
And then
just pen that into that temporary order.
Sure. How much was it?
Say it was $475. Let me confirm.
Because I maybe between now and Friday, I can check with admin and see if we can do like a special set, like a 30-minute slot on the 10th, maybe like at 11:30 or something. I'll look into that and see if I can offer that up, because I understand the delay, and if we actually think we'll have reports back, but I also want everybody to have an opportunity to actually discuss those reports.
I'll send an email also to Ms. Kale to see if she's available on the 10th at 11-ish, 11:30-ish.
Okay.
Go ahead.
I have a sentencing at 9 a.m. That morning that they're anticipating taking 1 to 2 hours. So that's, so I would think that 11:30 would work, but okay. Let me just make a note of that. Okay. And then did you find the amount for the,
Yes, it's $475.
Okay, so I just included that in the section 14. I just said other orders, reimburse $475 to respondent's attorney's office for hair follicle tests to be paid by petitioner within 90 days of this order.
Okay.